ಹಲೋ, ಅಡ್ವೊಕೇಟ್ ಸ್ವಾತಿ ಚಾನೆಲ್ಗೆ ಸ್ವಾಗತ. ಇವತ್ತಿನ ವಿಡಿಯೋ ಅಲ್ಲಿ ನಾವು ಕೇರಳ ಸಿವಿಲ್ ಜಡ್ಜ್ 2023 ಪೇಪರ್ನ ಸಾಲ್ವ್ ಮಾಡೋಣ. ಕೇರಳ ಪೇಪರ್ ರೀಸೆಂಟ್ ಆಗಿ ಹೆಲ್ಡ್ ಆಗಿರೋದು ಇದೇ ತಿಂಗಳು ಸಿವಿಲ್ ಜಡ್ಜ್ ಪೇಪರ್ ನಡೆದಿದೆ ಕೇರಳ ಅಲ್ಲಿ. ಸೊ ಹಾಗಾಗಿ ಈ ಪೇಪರ್ ಅಲ್ಲಿರುವಂಥ ಕರೆಂಟ್ ಅಫೇರ್ಸ್ ಆಗಲಿ, ಈ ಪೇಪರ್ ಇರುವಂಥ ಕ್ವೆಶನ್ಸ್ ಆಗಲಿ ನಮಿಗೂ ಸಹ ಕರ್ನಾಟಕ ಜುಡಿಷರಿಗೆ ರಿಪೀಟ್ ಆಗುವಂಥ ಸಾಧ್ಯತೆ ಇರುತ್ತೆ. ಅದಲ್ಲದೆ ಬೇರೆ ಸ್ಟೇಟ್ ಜುಡಿಷರಿ ಪೇಪರ್ಸ್ ಹೇಗಿರುತ್ತೆ, ಯಾವ ಲೆವೆಲ್ಗೆ ಕ್ವೆಶನ್ಸ್ ಕೇಳ್ತಾರೆ, ಯಾವ ರೀತಿ ಕ್ವೆಶನ್ಸ್ ಕೇಳ್ತಾರೆ ಅನ್ನೋದು ತಿಳ್ಕೊಳ್ಳೋದು ತುಂಬ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ಪ್ರತಿಯೊಂದು ಸ್ಟೇಟ್ದು ಆದಷ್ಟು ಜುಡಿಷರಿ ಪೇಪರ್ಸ್ನ ಸಾಲ್ವ್ ಮಾಡೋದ್ರಿಂದ ನಮ್ಮ ಪ್ರಾಕ್ಟೀಸೂ ಸಹ ಹೆಚ್ಚಾಗತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ಇವತ್ತಿನ ವಿಡಿಯೋ ಅಲ್ಲಿ ನಾವು ಕೇರಳ ಜುಡಿಷರಿ ಪೇಪರ್ನ ಸಾಲ್ವ್ ಮಾಡೋಣ. ಇದಕ್ಕೂ ಮುಂಚೆ ನಾನು ಆಲ್ರೆಡಿ ನಿಮಗೆ ಬ್ಯಾಚಸ್ ಅನೌನ್ಸ್ ಮಾಡಿದ್ದೀನಿ. ಹೊಸ ಬ್ಯಾಚ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಕರ್ನಾಟಕ ಜುಡಿಷರಿ. ಸೊ ಈ ಒಂದು ಬ್ಯಾಚ್ ನಿಮಗೆ 1st June ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಆ್ಯಂಡ್ ಅಡ್ಮಿಷನ್ಸ್ ಆಲ್ರೆಡಿ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಸೊ ಹಾಗಾಗಿ ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದಲ್ಲಿ ನೀವು ಬ್ಯಾಚಸ್ಗೆ ಅಡ್ಮಿಷನ್ಸ್ ತಗೊಳ್ಬೋದು. ಬ್ಯಾಚಸ್ನ ಫೀಸ್ ಕೇವಲ 5,000 ರೂಪೀಸ್ ಆ್ಯಂಡ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರುವಂಥ ಸ್ಟೂಡೆಂಟ್ಸ್ ನೀವು ಆದಷ್ಟು ಬೇಗ ಎನ್ರೋಲ್ ಮಾಡಿಕೊಂಡ್ರೆ ನಿಮಗೆ 5,000 ರೂಪೀಸ್. ಅದಲ್ಲದೆ ಆ ನಂತರ ಅಂತಂದರೆ 10 ಸ್ಟೂಡೆಂಟ್ಸ್, ಫಸ್ಟ್ 10 ಸ್ಟೂಡೆಂಟ್ಸಿಗೆ ಅರ್ಲಿ ಬರ್ಡ್ ಆಫರ್. ಆ ನಂತರ ಜಾಯಿನ್ ಆದಂಥ ಸ್ಟೂಡೆಂಟ್ಸಿಗೆ 7,000 ರೂಪೀಸ್ ಆಗುತ್ತೆ ಫೀಸ್. ಈ ಬ್ಯಾಚ್ ನಿಮಗೆ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆಗಿರುತ್ತೆ. ಕಂಪ್ಲೀಟ್ ಪ್ರತಿಯೊಂದು ಸಬ್ಜೆಕ್ಟ್ ಡಿಸ್ಕಸ್ ಆಗುತ್ತೆ, ಲೈವ್ ಕ್ಲಾಸಸ್ ಇರುತ್ತೆ. ಪ್ರತಿಯೊಬ್ಬ ಸ್ಟೂಡೆಂಟ್ಗೂ ಸಹ ಪರ್ಸ್ನಲ್ ಗೈಡೆನ್ಸ್ ಸಿಗುತ್ತೆ. ನಿಮ್ಮ ಸ್ಟ್ರೆಂತ್ ಏನು, ನಿಮ್ಮ ವೀಕ್ನೆಸ್ ಏನು ಅನ್ನೋದನ್ನು ತಿಳ್ಕೊಂಡು ನಿಮಗೆ ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಮೇಲೆ ಯಾವ ರೀತಿ ಕಮಾಂಡ್ ತಗೊಳ್ಬೇಕು, ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಮೇಲೆ ಎಷ್ಟು ಫೋಕಸ್ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ ಎಲ್ಲನೂ ನಾನು ಪ್ರತಿಯೊಬ್ಬ ಸ್ಟೂಡೆಂಟ್ ಜೊತೆನೂ ಪರ್ಸ್ನಲ್ ಆಗಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀನಿ. ಅದಲ್ಲದೆ ನಿಮಗೆ ಹೇಗೆ ಎಕ್ಸಾಮ್ನ ಕ್ಲಿಯರ್ ಮಾಡಬೇಕು ಅನ್ನೋಂಥ ಒಂದು ಟಿಪ್ಸ್ ಟ್ರಿಕ್ಸ್ ಆಗಲಿ ಪ್ರತಿಯೊಂದು ನಿಮಗೆ ಕ್ಲಾಸಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಿ. 2 ಸಕ್ಸಸ್ಫುಲ್ ಬ್ಯಾಚ್ ಜೊತೆಗೆ ಈ 3rd ಬ್ಯಾಚ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದಕ್ಕೆ ತುಂಬ ಖುಷಿ ಆಗುತ್ತೆ. ಆ್ಯಂಡ್ ಇಷ್ಟು ಉತ್ಸಾಹ, ಇಷ್ಟು ಹುಮ್ಮಸ್ಸನ್ನು ಕೊಟ್ಟಿರೋದಕ್ಕೆ ನಿಮ್ಗೆಲ್ಲರಿಗೂ ತುಂಬಾ ಥ್ಯಾಂಕ್ ಯು ಅಂತ ಹೇಳ್ತೀನಿ. ನೀವು ಪದೇ ಪದೇ ಕೇಳ್ತಿರೋದ್ರಿಂದ ನಿಮ್ಮ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮೇರೆಗೆ ಈ ಬ್ಯಾಚ್ ಲಾಂಚ್ ಆಗ್ತಿರೋದು. ಸೊ 1st June ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿರೋಂಥ ಬ್ಯಾಚಿಗೆ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇರುವಂಥ ಪ್ರತಿಯೊಬ್ಬ ಕ್ಯಾಂಡಿಡೇಟ್ ಜಾಯ್ನ್ ಆಗಲಿ. ಕರ್ನಾಟಕ ಜುಡಿಷರಿ 2023 ತುಂಬಾ ಈಸಿಯಾಗಿ ನೀವು ಪ್ರಿಲಿಮ್ಸ್ನ ಪಾಸ್ ಆಗಬಹುದು. ಆ್ಯಂಡ್ ಈ ಕರ್ನಾಟಕ ಜುಡಿಷರಿ 2023 ನಿಮ್ದಾಗಲಿ, ಈ ವರ್ಷ ನಿಮ್ದಾಗಿರಲಿ ಅಂತ ನಾನು ಹಾರೈಸ್ತೀನಿ. ಬನ್ನಿ ವಿಡಿಯೋನ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ದಲ್ಲಿ ನೀವು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಎಲ್ಲ ಕಮೆಂಟ್ ಸೆಕ್ಷನಲ್ಲಿ ಕೊಟ್ಟಿರುವಂಥ ವಾಟ್ಸ್ಆ್ಯಪ್ ಲಿಂಕ್ ಮುಖಾಂತರ ವಾಟ್ಸ್ಆ್ಯಪ್ ಗ್ರೂಪ್ಗೆ ಜಾಯ್ನ್ ಆಗಿ ಎನ್ರೋಲ್ ಆಗಬಹುದು ಕ್ಲಾಸಸ್ಗೆ. ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. Question number 1. A civil court have no jurisdiction over suits if the amount or value of the subject matter of such suits exceed its pecuniary limits of ordinary jurisdiction section dash of CPC says so. So answer ಇದಕ್ಕೆ question number 1 answer C section 6 of CPC ಹೇಳುತ್ತೆ. ಕೇರಳ ಜುಡಿಷರಿಯಲ್ಲೂ ಸಹ ಸ್ವಲ್ಪ ಟಫ್ನೆಸ್ ಜಾಸ್ತಿ ಇರುತ್ತೆ, ಬಟ್ ದೆನ್ ಕರ್ನಾಟಕ ಜುಡಿಷರಿ ಹಾಗೇನೆ ಸೆಕ್ಷನ್ ಬೇಸ್ಡ್ ಕ್ವೆಶನ್ಸ್ನ ಜಾಸ್ತಿ ಕೇಳ್ತಾರೆ. The Supreme Court of India in Dhulabhai versus State of Madhya Pradesh laid down the principles governing A. Res judicata, B. Territorial jurisdiction of civil courts, suits relating to minors, exclusion of jurisdiction of civil courts. Correct answer ಬಂದು option D. Exclusion of jurisdiction of civil courts. Question number 3. An agreement to sell an immovable property situated at Ernakulam was executed at Bangalore. The buyer resides at Kottayam. The seller resides at Kozhikode. The agreement fell through. The seller wants to file a suit for compensation. Where can he institute the suit and why? Correct answer ಬಂದು option B. Kottayam, since the buyer resides here. Question number 4. The principal sum adjudged would be the sum actually loaned plus the amount of interest on periodical rests, which according to the contract between the parties or the established banking practices has stood capitalized. Interest pendent light and future interest, that is interest post decree not exceeding 6% per annum, shall be awarded on such principal sum, that is the principal sum adjudged on the date of suit. A constitution bench of Supreme Court of India held so in in the case of Central Bank of India versus Ravindra 2002. Question number 5. A decree holder seeks sale of property belonging to the judgment debtor so as to realize the amount due under that decree. The property lies outside the jurisdiction of the court which passed the decree. The judgment debtor raised an objection to lack of jurisdiction to the court which passed the decree. Which among the following is correct? Options: A. Court which passed the decree alone can order sale. B. Decree for realization of money cannot be transferred to another court. Court where the property is situated alone can order sale. Order for transfer of decree has to be obtained from the district court. Correct answer bandu option C. Court where the property is situated can alone order the sale. Question number 6. A decree passed by a munsif is modified by the High Court in second appeal. When the decree was put in execution, the judgment debtor questioned its executability by filing a petition under section 47 of the CPC. The decree holder would contend that such a question can be decided only by the High Court or in a separate suit. Choose the correct statement. Correct answer bandu option D. Court executing the decree has to decide the question. ಇದು ಕೊಟ್ಟಿರುವಂತದ್ದು section 47 ಅಲ್ಲಿ. Question number 7. A suit dismissed for default was restored. The order allowing restoration, the plaintiff was directed to pay the defendant costs of rupees 20,000. Cost remained unpaid and hence the defendant filed an execution petition. It is dash. It is maintainable in the light of provisions of section 36 of the CPC. Question number 8. The court after trial found that the plaintiff is entitled to the declaration of the title as claimed, but the court refused to grant a decree. Which among the following would be the reason? The reason would be consequential relief is not claimed. Question number 9. A is government servant. He has monthly salary of rupees 31,000. He is the judgment debtor in a money suit. What is the portion of his salary attachable in the execution of the decree? Correct answer bandu idakke option C, 10,000 rupees. 1/3 of the salary attach agutte, given in section 60. Question number 10. Statement 1. In a suit filed under section 92 of the CPC, leave of the court is a precondition for institution. Statement 2. In a representative suit under Order 1 Rule 8 of the CPC, leave of the court is not a precondition for institution. Correct answer idರಲ್ಲಿ both the statements are correct. Statement 1 and statement 2 are correct. Question number 11. The second suit was in respect of the same cause of action as that on which the previous suit was based. Respect of that cause of action, the plaintiff was entitled to more than one relief, and having entitled to more than one relief, the plaintiff without obtaining leave from the court omitted to sue for the relief for which the second suit had been filed. Correct answer idakke option B, under Order 2 Rule 2 of CPC. Order 2 Rule 2 bandu relinquishment of part of claim ಬಗ್ಗೆ discuss ಮಾಡ್ತೀವಿ. Question number 12. What is meant by registered address used in CPC? Registered address ಅಂತಂದ್ರೆ address of the party given in the pleadings. Order 6 Rule 14A. Registered address. Question number 13. Under Order 8 Rule 1, Order 8 Rule 1 CPC stipulates that the defendant shall within 30 days from the date of service of summon on him present a written statement of his defense. The time stipulated in Order 8 Rule 1 is directory. Idu mandatory time alla, this is directory. Question number 14. In a suit, the defendant filed a counterclaim. When the suit and counterclaim are taken up for trial, the plaintiff failed to appear in court. What does the court do? Answer option A. Dismiss the suit and proceed with the counterclaim. dismiss the suit and proceed with the counterclaim. Question number 15. Where issues both of law and of fact arise in the same suit, the court is of opinion that the case or in any part thereof may be disposed of on an issue of dash. Only it may try that issue first if that issue relates to the jurisdiction of the court or a bar to the suit created by any law for the time being in force. Correct answer is option A. On the issue of law. Order 14 rule 2 ali discuss agade. Question number 16. On the day to which the hearing of a suit is adjourned, the plaintiff alone appeared. The court, after recording his evidence, proceeded to decree the suit by answering the issues. Correct answer? Option D. Decree is an ex parte 1 and an application under Order 9 Rule 13 of the CPC will lie. Question number 17. A notice under the Order 21 Rule 37 of the CPC was served on the judgment debtor. He failed to appear in the court. Hence, the execution court recorded evidence of the decree holder. The court, on convincing that the judgment debtor has enough means to pay the decree, debt issued a warrant for his arrest. He was arrested and produced. The court shall ask the decree holder to prove the means of the judgment debtor. Question number 18. The plaintiff in a suit wants to admit in evidence a certified copy of commission report obtained in another suit between the same parties. The plaintiff would contend that a report of the commissioner shall be evidence in the suit in the light of the provisions of Order 26, Rule 10, Clause 2 of CPC, and hence the report shall be received in evidence. Can the report be admitted in evidence? Correct answer is option C. Report can be admitted in evidence only if it is proved by examining the commissioner. Question number 19. In an order of temporary injunction is granted without notice to the defendant, the court shall ensure all of the above, recording of the reasons of its opinion that the object of granting the injunction would be defeated by delay, that the application for injunction together with the documents specified in the behalf and delivered or sent on to the defendant by the registered post, that the affidavit stating the such copies have been so delivered or sent is submitted by the defendant. All of the above are correct. Question number 20. A caveat shall be valid for. Caveat shall be valid for 90 days from the date on which it was lodged. Caveat L ಕೊಟ್ಟಿದ್ದಾರೆ 148A. Question number 21. A executed a promissory note on 1st January 2018 undertaking to pay 20 lakh to B. The debt remained unpaid on 1st May 2022. A executed another promissory note undertaking to pay the amount due under the promissory note dated 1st January 2018. B filed the suit based on the promissory note dated 1 May 2022. Is the suit barred by law of limitation? No. A barred debt can be consideration for the written instrument. Yellide idu Order 8 Rule 4. Question number 22. Which one of the following is not a novation of contract? Idralli yavadu novation of contract alla. Novation section 62 of Indian Contract Act al kottide. So A owes B rupees 10,000. A enters into an agreement with B and gives B a mortgage of the A's estate for rupees 5,000 in place of the debt of rupees 10,000. So answer idu alla. This is not novation. B. A bid a tender for the construction of the bridge and executed the contract. A. And the employer later agreed that once the bridge is constructed, A shall be allowed to operate the bridge for 20 years. So, idu novation of contract. ಅಲ್ಲ. ದಿಸ್ ಇಸ್ ಆಲ್ ಫಸ್ಟ್ ನೊವೇಷನ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಸೊ ರಿಮೈನಿಂಗ್ ಇನ್ನೆರಡೂ ಸಹ ನೊವೇಷನ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಗಿರುತ್ತೆ. ಇಫ್ ಎ ಅಂಡ್ ಬಿ who are the parties to the contract agree to perform the contract, yes, it's novation. A and B are the parties to the contract. They and C agree to be together with C will perform the contract. Yes, this is novation. The suit is one for compensation for breach of contract. In the contract, a penalty of rupees 10 lakh is stipulated in case of contract is broken. The defendant admitted non-performance but denied any loss to the plaintiff. The court decreed the suit of rupees 10 lakh, holding that since the defendant admitted non-performance, no further inquiry is permissible. So the decree is incorrect since the liability of the defendant is to pay reasonable compensation not exceeding the amount of penalty stipulated in the contract. Question number 24. A suit is instituted for a decree to declare that the contract is invalid since it is tainted by undue influence. No further relief is claimed if a decree for declaration is granted. Which among the following is correct? Option B. Undue influence vitiates the contract in making voidable and therefore decree is incorrect. Undue influence ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ಸೆಕ್ಷನ್ 16 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಫ್ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್. Question number 25. In a suit for realization of money, the second defendant surety contended that without his knowledge, the first defendant principal debtor alienated the hypothecated property and hence he is not liable for debt. The contention that the second defendant is valid since he is discharged under section 139 of Indian Contract Act. Section 139 discharge of surety ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಉಳಿದಂಥ ಕ್ವೆಶನ್ಸ್ ನಾವು ನೆಕ್ಸ್ಟ್ ವಿಡಿಯೋ ಅಲ್ಲಿ ನೋಡೋಣ, ನೆಕ್ಸ್ಟ್ ವಿಡಿಯೋ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ. ಸೊ ಈ ರೀತಿ ವಿಡಿಯೋಸ್ ನಿಮಗೆ ಇನ್ನಷ್ಟು ಮಾಡಬೇಕು, ಈ ರೀತಿ ವಿಡಿಯೋಸ್ ನಿಮಗೆ ಇಷ್ಟ ಆಗುತ್ತೆ, ಈ ಕಂಟೆಂಟ್ ಇಷ್ಟ ಆಗುತ್ತೆ ಅನ್ನೋದಾದರೆ ಪ್ಲೀಸ್ ಸ್ವಾತಿ ಅಡ್ವೊಕೇಟ್ ಚಾನೆಲ್ನ ಲೈಕ್, ಶೇರ್ ಹಾಗೂ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ ಆ್ಯಂಡ್ ನಮ್ಮನ್ನು ಇನ್ನಷ್ಟು ಅಪ್ಡೇಟ್ಸ್ಗಾಗಿ ಫಾಲೋ ಮಾಡ್ತೀರಿ. ಹೊಸ ಬ್ಯಾಚ್ಗೆ ಜಾಯ್ನ್ ಆಗಬೇಕು ಅಂತ ಅಂದ್ಕೊಂಡಿರೋಂಥ ಸ್ಟೂಡೆಂಟ್ಸ್ ನೀವು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋಂಥ ವಾಟ್ಸ್ಆ್ಯಪ್ ಲಿಂಕ್ ಮುಖಾಂತರ ವಾಟ್ಸ್ಆ್ಯಪ್ ಗ್ರೂಪ್ಗೆ ಜಾಯ್ನ್ ಆಗಿ ನಿಮ್ಮನ್ನು ನೀವು ಎನ್ರೋಲ್ ಮಾಡ್ಕೊಳ್ಬಹುದು. ಆ್ಯಂಡ್ ಅರ್ಲಿ ಬರ್ಡ್ ಆಫರ್ ನಡೀತಿದೆ. ಸೊ ಹಾಗಾಗಿ ಆದಷ್ಟು ಬೇಗ ಅಡ್ಮಿಷನ್ಸ್ನ ಮಾಡ್ಕೊಳ್ಳಿ ಆ್ಯಂಡ್ ಈ ವರ್ಷದ ಪ್ರಿಲಿಮ್ಸ್ ನಿಮ್ದಾಗಿಸ್ಕೊಳ್ಳಿ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.